At the beginning, actually, I asked you what is the difference between an investigation and data acquisition. Actually, as per the primordial question, the primordial definition of both, investigation to be done by an investigator, data acquisition to be done by a forensic specialist. Uh, Investigate. Actually, we start with the data acquisition. Why? Because every each single crime which we are going to process today, which we are going to see in our unit today, has to start with a planning. What are the steps to pass through in order to finalize the answering of all questions related to the crime. That is a context of data acquisition, data gathering. That is a scenario via which we build a plan, or the forensics specialist builds a plan to finalize his forensics task. While actually the task of investigation, it is a context of data acquisition in deep. It is a scenario via which we are the forensics specialist is going to investigate the events happening within the crime, the steps. For example, he's gonna investigate the interferent parties if the crime has happened in an environment where let's say uh, people visualize that were available. So he's gonna investigate the available parties. Let's say in this scenario. So investigation is a context of an in-deep data acquisition because it is a specialized, it is a classified, it is more narrowed data acquisition. No more, no less. Simply. So, regarding this unit, actually, what we're going to see through this unit, the most important part, what it concerns to us, we're not going to see the laws as per the, let's say, legal law, but we are going to see the processor of crime in a scene versus the digital environment. What we are concerned how to retrieve the digital evidence, how to classify and what are the digital evidences, and so on. So, what we are going to take care is not the context of the crime itself, but the scenario, but the scenario of the digital evidence extraction, not the scenario of the um, because actually the processing of the scene is not the scenario of the only software to install and the computer to have to retrieve data or retrieve, let's say, the required context. No, but beside of that, it's not beside, but what we are going to just narrow our searching is that the digital context only what we are going to um, use as a digital environment. Let's just have a look on the objectives. So the first thing actually we're going to classify what are the digital evidences, what are the digital evidence, how we classify that this is a concerned digital evidence. Then after we're going to see how to collect it, what are the tools to be utilized, samples of tools to use to extract digital evidence. Yes, and we see beside of that, I was insisting on here that we are not going to tackle the laws because this book actually and this reference we are referring to, it has a good demonstration of the United States uh, digital forensics law, and in the context of processing the crime scene, the crime or the incident scene, it is presenting a list of laws that manipulates the yeah, but it tackles the scenes or the events in between. We are not required, actually, as per our course, we are not required to uh, have all the knowledge regarding the laws in this regard, but we have to recognize what we uh, what we need. The first part is to identify the digital evidence, and to identify digital evidence, we have to define it. What is a digital evidence? So, digital evidence is an evidence that an investigator or that a digital forensic expert would stand on in order to say that this is a proof, or this is, yes, this is a proof to answer first question, second question, or whatever, a given question. Digital evidence, it can be actually for our concern, it can be any sort of an electromagnetic resource stored in a digital, let's say, in a, let's say, storage media. So any information that can be beneficial, and it has to be actually, I said electromagnetic means it has to be stored in a storage device, in a digital, let's say, hard disk, a flash disk, a CD, whatever, all these storage medias we know. It's not only we know all the storage medias in plural commercialized that can be actually concerned. So the information that has to have be stored in a yes, in a sort of a digital media, yes, it is classified to be digital evidence if found, if usually found, or yes, retrieved. From the rules, actually, since it is an electromagnetic and it is stored in a digital media or something like that, so it's not visualizable. It's not something that physically we can manipulate. It is not something that we can go beyond manually. No. Yet, still, it is to be considered upon different laws. It is still to be considered as a physical evidence. Physical means when we talk about a paper or something, actually, you can manipulate in a handy way. That is a physical evidence. Digital evidence is not. It is something actually. Can we touch those slides, or can we touch anything available inside the computer or any computerized device? Answer is no. Yet, with this logical aspect of the digital evidence still to be considered upon the law, no, upon actually our reference here, it is to be considered as a physical evidence. Yeah, and the same law actually that admits that this digital evidence to be a physical one and to be accepted as a physical evidence. The same one, it might impose here policies and politics how to present this digital evidence, this retrieved digital evidence, how to be presented to the court. Means when it says it has to be actually printed, as per our reference, it says that it has to be printed. This law, this United States of America law, says that it has to be printed. This is an example of how the shape, the way, the presentation of this digital evidence to the court, how it has to look like. Come on, yes. So, digital evidence is a sort of a media to be stored on a digital device, whatever all the storage medias we know, or the commercialized ones, whatever, or utilized ones. And this logical content, once retrieved and available, upon to different laws, not only this US, actually the United States given law, but upon different laws, it is to be considered as a physical evidence. Logical evidence means something we cannot see, we cannot manipulate in a handy way. Can we touch it? Can we see it in a 3D mode? No, we cannot. It's not to be visualized that way, and it is not to be displayed that way. Yet, still to be considered physical here, for sure. And this is upon the way how to be presented to the court. This logical, invisible, and manipulated. It's not invisible, but unmanipulated in a physical environment. There are politics how to visualize and to present to the court in order to be considered as a physical evidence. Uh, those investigators responsible for retrieving the digital evidences, those investigators of the parties, digital forensics responsible for taking the care of retrieving the digital evidences, they have different tasks to do, and this is based on their experience only. They have to be capable to identify, to recognize what are the evidences to be considered as evidences, because in a storage media, or let's say in a given storage media, there might be actually data from a history from an old age which is already erased, or let's say having a sort of let's say hidden mode or something like that, but it is not related to the crime scene or to the incident scene. So that way, those people here, they have to identify what are the responsible, let's say, evidences, let's say the related evidences to the incidents in question. They have to have the capability to retrieve it, yes, keep it with them, yes, and store it also for a future use, to present it to the court or to analyze it or whatever for future use. Because remember, as per the first unit and second unit we saw, we said that the storage of the medias, it needs not a context of just yes, I found and that's it. You keep it in the same storage. No, no, no. There have to be actually a way how to retrieve it, and the storage, it needs to be in a secure environment. The security related to where we store, or forensics experts has to store their evidences. It has to be actually in a secure environment, whether it is a logical environment or a physical environment. Why? To avoid the data, let's say, uh, omission or deletion, or let's say any damage to be caused to that retrieved evidences or list of evidences. Yes. So the collection here and the matter of preserving what it has to be collected, it is one of the tasks that those investigators has to cover. Evidences to be evidences, and if we are talking about a list of evidences, there might be actually an order to there might actually upon the crime scene investigated, there might be an order via which we have to present those evidences in order to say yes, because of this sequential view, we are seeing the evidence. With no, let's say, with another order, we cannot see the evidence. So thus, and this way only, and this way only, and this way only, we have to demonstrate the context of the orders, or the amount of the analysis or the identification of those evidences. This is upon usually the crime or the incident to be processed, and this way only, when you say that an evidence has to be repeated and let's say rebuilt again and again, means what we have extracted, it has to be stored somehow later on during the investigation period, or later on after a while, or after finalizing the case, or after at the time of presenting it to the court. It needs to be, for example, rebuilt as per the example I given, which is, for example, the order. So it has to be, there have to be a chance that the investigator has to present this evidence, or this extracted evidence. If not, here I can give you exactly a question, or we might face a question saying that an investigator was able to extract whatever an evidence, yes, analyze it and do all the tasks during the time of the extraction. But after a while, to present it to the court, he failed. Who he or they failed? The investigators failed to rebuild the evidence structure, failed to reanalyze or to organize the evidences in the order where they can say and present the answers. So this is not actually admitted, and this is not to be admitted in the sense of failure. I presented only the example of the ordering. It's not the unique approach via which processing the evidences, the extractive evidences to be done. It's not the unique processing task, but because of the sequential and the systematic actually approach to finalize the processing of a crime scene or an incident scene, because an event, it might have to include external scenes. An incident scene, actually, we can consider it an incident, but it's not a crime scene. So the ordering or the sequential order or the systematic order or systematic approach is one of the tasks that investigators has to also achieve. Any questions here at this level?
Not exact.
Usually, actually, when we say that it is an evidence, so it has to give an answer to a question. Usually, what is the evidence to the crime number one? What is the evidence to the incident number one? What is the evidence to the crime number two? What is the, let's say, the evidence, sorry, to the incident number two, and so on? How we say that this is an, because it has to answer a question or a list of questions. It has to enhance what you think, what you thought, as an investigator, what you were feeling doubt about. So there have to be actually, it has to give answer or answers to specific doubts. Yes, and because actually remember when we try to, or the investigators try to extract evidences, they would actually use, they might use public, or let's say private, or let's say whatever, not legitimate. It's not legitimate, but they might fall into a case of breaking privacy when they use personal storage medias, or when they use personal devices. They might fall into a case of breaking the privacy. So the evidences, the extracted evidence, they have by must to be considered as evidences, whether physical or logical or whatever the case, they have by must to comply to the rules, to the federal rules. In the case, federal means to the law. Because if they do not comply to the law, they would not be considered as evidence, even if they are clearly given and clearly extracted and fully extracted. So if they do not comply to the law, so they would not be considered as evidences. Whatever the case, whatever the law we keep actually we talk about. And those rules we were talking here, and those laws that we were talking here, actually they are context of Maybe we may talk about regional policies, politics, cultural policies and politics, governmental and let's say administrative politics and policies, and so on. So they are not standardized context of uh, they are not standardized rules or politics to be standard for all and for everybody and everywhere in all countries. No, it's not. It's not the case, because from a country to a country differs the law, and from a region to a region, not only a country to a country, the law and the policies differ, and so on. From a language to a language, laws differ, and so on. So those concerns here of those rules, it is context of regional approach. First of all, when you say actually state rule, when you say, come on, when you say state rule, actually it's a context of regional approach to visualize, because if it does not meet the regional benefit, it would not be actually admitted as a federal rule. Cultural aspect and regional aspect, it is to be considered by the federal, the imposed federal laws and rules. So this is what we talk about rules, what is defined as rules. And usually actually there have to be actually a severe precaution to deal with the digital evidence. Why? Because the content has to it might have the chance to be altered, detailed, modified, much more easy when we compare it to a real physical evidence. A data written in a flash disk, it is much more easy to modify or to alter it when we compare it to a paper-based evidence. Even is actually whatever. Let's continue. As per the hearsay evidence, now we are having a different view when we said that earlier that the digital evidence is considered to be as a physical evidence. Let me come back to the respective slide. Yes, to the, as a physical evidence. Here we are saying that the costs or the costs they are considering the digital evidences are as a hearsay evidences, which are to be a second proof, not a secondary proof. It's not a prime, let's say, a primordial and primary proof when we talk about investigating a crime or an incident scene. But still, even because even real physical evidences, there are primarily and let's say primordial evidence to be considered, others to be secondary, others to be tertiary, and so on. So the same way. But here, since it is digital only, they are secondary. These are as per the law. These are as per the law only. Secondary to what? If we are having two evidences, means if the investigator do presents two evidences to the court, one is a paper and another one is an evidence from a hard drive. Immediately and trivially, the court will consider the paper as a primary evidence, and the hard drive, the content from the hard drive will be considered as a hearsay. Hearsay means second evidence, secondary or second-hand evidence. Those rules here actually they are to also not only the ones set by the law. They are not only the federal rules. They are not only the federal laws, but also the incorporation rules. They are considered to be actually as policies or politics to be admitted for retrieving evidences. Yeah, the policies, as per an example, work time has to be from 8 to 4. These are rule that has to be admitted because we do not, it's not in all cases we can force the employees to work overtime. It's not in all cases. There are constraints. As an example, the time of work. So whatever. Here, what we have to note, let's say, elevate is that the incorporation policies and politics they are to be considered here as rules also whenever we are talking about evidence extraction. Mainly the rules they are federal rules, yet the exceptions are available. Exceptions are available. You will not find them usually and frequently, yet they have to be actually recognized by the digital forensics or the investigators specifically. And because of those, let's say, incorporation considerations, contents are, let's say, accessible and to be considered as data to check and to analyze and to, let's say, organize for the purpose of searching the evidences, if they comply to the business, let's say, to the rule, to the incorporation rules. So if they do comply to the incorporation, they are to be considered as, yes, to be seen and to be analyzed and to be checked. And because of this saying only, remember that the incorporation workers they might be actually sort of insiders. What does it mean? As per an example, they might bring their own devices. They might use their own mobile devices. Might use their own laptops and so on. And because of this reason only, the classification of the records they are either general ones or the stored ones. Actually, in the sense of general ones, we see that they are examples of they might cover all, but generally we talk about the non-classified to specific rule or specific sector of business. Those are the general ones. The stored records they are classified and they are already analyzed. They belong to a dedicated group. They belong to a dedicated department, as per an example, and thus they are stored, and thus they are already in rest mode. The general ones, they are still acquiring analysis to happen, to be classified or to be utilized again and again and again. So if they are not at the end of the day, actually the incorporation or the in business or the in incorporation, yes, rules, if they do not actually represent a trustworthy value, they are not to be considered. In the sense of the incorporation, let's say rules or politics, if they do not present a trustworthy records, means the data itself, we do not actually consider those neither the incorporation or the business record, or let's say business based rules, nor the extracted records themselves, the data itself. Otherwise, the court will not accept that. The court will not accept that. As per the first chapter, if you remember very well, actually, we said that the investigators has to contest and defend the findings. The investigators, at the end of the day, they are people who extracted evidences and they said based on their analysis Those are the evidences to answer the questions 1, 2, 3, 4, and so on. Okay, they would be actually facing, let's say, teams and committees to defend their findings. So this is a challenge, a sort of a challenge to consider. And here, the rules imposed, whether they are federal or the incorporation rules, they are a sort of a challenge that the investigators will face. And how they would face, actually, because an investigator will extract an evidence against a crime and a criminal, both. And the criminal will defend himself. So this way, whatever he finds or whatever the investigators find, they would challenge. They would be actually put into a challenge to defend their findings, no more, no less. Examples of, let's say, data to extract, which is the templates. The word templates, the Microsoft document template. Template is a sort of dedicated, yes, word file. It's a sort of a word file because the template is not the doc, it's the T doc or something like that, whatever. But those are sorts of, this is an example only. So refer to the book, please. Or demo. Yes, this is the interface. Yes, it is an old operating system, but still actually those are sorts of evidence that makes us understand how data to be extracted. Any questions, Aya?
No, stop.